Ready when you are, my friend.
Well, let's get this party started. Okay, I'm Bobby Hacker. I'm the president of the Sports Lawyers Association. I'm here with a longtime member and sponsor of the Sports Lawyers Association, and an even older and closer friend of mine, Jon Velie, who's the CEO of OnlineVisas. Jon has been a big part of growing the expanse of what we at the Sports Lawyers Association do by bringing some of the first immigration discussions to our annual conference. Much like everything else that we have going on today, we've unfortunately lost the ability for in-person contacts, but through the wonders of technology, we're able to engage with our colleagues through various forms of media. And this is one today where we're doing a webinar that's really being presented by Jon. Real quickly, a quick word on the Sports Lawyers Association. For those of you that aren't aware, we're a national organization, actually an international organization of lawyers involved in the sports industry, which covers pretty much every discipline you could think of. And given that sports law is an amalgam of all the disciplines of the law, we have a broad reach. So Jon fills in one of those gaps with his expertise in the immigration world. I think that we have, as in the Sports Lawyers Association, have dealt with the pandemic as part of our what we like to call SLA 2.0, which is to provide more content through more forms of media. Traditionally, our organization did an annual conference, but over the last year, we've started adding podcasts. When our conference was canceled, we began to push out webinars, and we have a webinar package available with your continuing legal education credits available. Our site is robust with all sorts of other content, blogs, articles, sample contracts, et cetera, et cetera. We're a membership organization, so I urge those of you that aren't members to join. My sales pitch is now done. Let's talk about the specifics of today. I think we live in a very changing world, and in the sports world in particular, here in America, it's not all about American athletes. If you look at the NHL, the NBA, Major League Baseball in particular, you're finding lots of international players coming in. When you look at golf tournaments and tennis tournaments, I think that's been the case for a longer time. We have, unfortunately, been thrust into a world where it seems that a lot of the immigration law and the changes to what it takes to be able to come and work in this country have changed over the years with the politicalization of immigration. It's unfortunate because you have these extraordinary athletes who want to compete with the best in the world, and there are some hoops to jump through, and those hoops have changed. And for people like Jon in the immigration space, who's used to jumping through hoops, after many, many years of doing it, he now has learned that he's got new hoops to learn about and new hoops to jump through. So notwithstanding the power outage at his office, which forced him to fly across Norman to get home so that we could do this webinar, Jon's here to talk to us today about these special visas and green card opportunities for the extraordinary athlete wanting to compete in sports on our native soil. So Jon, the stage is yours.
Thank you, Bobby. I really appreciate it. Welcome, everybody. I see a number of you are here. If you want to ask any questions, please ask them. There should be some links on the dashboard to the right, allow you to ask a question. You can even raise your hand. I'll try to look at it to see if you've done, but I'm going to try to power through this stuff. There's a lot of things to cover today on the extraordinary ability visas. It's the O-1, that's the non-immigrant visa, and then the EB-1 green card. And I'm sure you're all ready to learn how that impacts you. Also, if you want to know more about this specifically, we offer free strategy sessions as part of our business model. So we're going to give you an overview today. If you want to dig into your facts, if that concerns you, someone you know, somebody you want to hire, we can help them too. So here we go. So this is a little background on me. I'm not going to go over that really well. If you want to learn more about what we've done, I'm glad to share that with you. But we've had an opportunity to represent some really excellent people in about 50 different sports over about 26 years. One claim to fame I love is that we did the first green card for a rugby player. This is up on me. And now representing all the major sports. And like I said, about 50 total. And it's not just sports, entertainment, technology, medicine, a lot of different things. So if you have any needs in that, give us a ring and we'll help out. We're at OnlineVisas.com is our website, and from that, let's go into it. So our agenda today is going to be an overview and general strategies. Wow, this jumps on me. Employment, analysis of the criteria, and questions and answers. So you must be able to demonstrate extraordinary ability in athletics through sustained national or international acclaim. Athletics can mean other people that are in sports that are not just the athletes. They can be the coaches, they can be administrators. We've done marketers in sports in that sort of deal. So, but that's kind of how it rolls. You must meet at least 3 of the criteria or provide evidence of a one-time achievement, such as an Olympic medal for this. In other things, it might be a Grammy, an Emmy, those sort of things. In other types of industries, as well as evidence that you'll be continuing to work in an area of your expertise under the EB-1. The one thing to remember is you don't need to be competing at the extraordinary ability level. You just need to have been extraordinary when you do it. There's a case called Kazarian. We'll get into that later and how it has sort of impacted how we do the analysis of these cases. So the first thing is to define the field. We call that, how big's your pond? You want to be the big frog in the little pond, not the little frog in the big ocean in this sort of deal. And the strategy I always start with folks is, what do you do and why are you one of the best that does it? Sorry that this thing's jumping. So essentially, what's your niche and what are your skills? And so if you're in sports, you don't have to be the greatest skier. You may be the greatest downhill skier. You may be the greatest synchronized skier. There's things that might be very narrow that you've really risen to the top at, but understanding at the beginning, we get to define it first. They don't define it for us. So understanding that is a really big point. So the first criteria is called documentation of, I hate the word aliens, but that's the thing. So the foreign nationals, receipt of lesser national or internationally recognized prizes or award. Again, if you have the one really major one, you don't need to go through this process. You just show it to them. But if you don't, that's what you need to do. Again, I apologize about the skipping on this. So it's really, what is the evidence? How does USCIS analyze the awards under the agency's, the adjudicator's field manual? That's what the AFM is. And then what's the analysis of those awards, right? So I think we'll get into that a little bit. So a case example, Miss Garcia was part of a team that won the national championship. It's supported by a case that's called, they leave it blank sometimes, where the service center denied an EB-1 petition because the petitioner's Olympic medal was won by a team. The AAO reversed that decision. We do not find the significance of the award is diminished because she was a relay rather than an individual medal, right? So the petitioner was personally awarded the bronze medal and was one of the relay swimmers to compete in that race. It's not the case where the petitioner was on the sidelines while his team won without his participation. Also, with a Harvard Medical School researcher, they found nothing in the nature of the work where a team diminishes the ability of the members of the team. What we're going for here is, can you be a member of a team and still get to be extraordinary, right? One of the pushbacks we get from USCIS is somebody won that not for themselves, but as a member of a team or a coach of somebody. These are the type of cases we use to support that. I'll go back a little bit and go through this a little bit more. So what's really important about the awards is the evidence. One of the things when we inherit these cases that we find that folks that don't do this enough do is they try to put it all in letters, right? Well, I have somebody that's really important that's going to write me a letter. All right, that's not enough. You must have evidence. I look at evidence in 3 types: primary, secondary, tertiary. 1, 2, 3. So primary evidence is like a brick. All right, so think of it like it is the award. It's a certificate of the award. It's an article about the award, right? These are things that are objective, not subjective. Letters are subjective. Immigration looks at them as worthless. They're only good to explain about that. So an expert can talk about why it's important. An expert can say what they did and why that was an impressive thing to do. The expert can't say, I was there and I saw them win it. That's not going to be enough. USCIS analyzes these awards under the adjudicator's field manual by looking at whether or not the award is national or international. What that means is, what is it not? It's not regional. It's not state. It's not a team award, right? Best player on your team is not a national or international award. I don't care how good the team is, all right? So that's kind of how you want to look at that. I'll move on. All right, these are some of the tips right here. Don't use the regional, state, team awards. Research what awards are out there for your sport. Look for publications in the name or list the best in the sport. That can be an award, right? So if there's every sport has numerous magazines that cover it. Sometimes those magazines may list the best people in that sport, the best ski instructors, who they think are the MVPs, those sorts of things. That can be an award. That can be a national award. That can even be an international award. The next one is criteria. I apologize, guys. I don't know what it is with this thing. It jumps on us. So documentation of membership in associations for which the classification is sought, which requires outstanding achievements of their members as judged by national or international experts in their discipline. The plain language of this is very important, all right? So it has to be an organization. It has to require outstanding achievements, and there has to be somebody who made that determination who's recognized as an expert, okay? So the evidence on here, this is another one where people like to use letters. Well, this organization put me in there and they write a letter. That won't work, right? You need to find their bylaws or some sort of written criteria. If it's a new organization, ask them to adopt that, right? To go through some process to put this into place so that you can say that. The big groups don't care. In sports, I often like to use national teams because national teams select their players from a large number of athletes. Sometimes in certain sports, you have to compete to do it. In track and field, you have to win certain awards, certain events to make the national team. In rugby, they select from regional or territorial provincial teams to make a national team. In other sports, there's variations, they do it, but they selection, and the selection can be done by a selection committee, possibly, maybe not just the coaches, but you want to know what their process is. If there was an event or something that they were a trialist for, and then they've won it, and then who did that, and what was the criteria they used, and how do they communicate that? You can use emails sometimes, certificates, other things, but you need to have that evidence. Again, a letter detailing it won't be enough.
John, can I ask you a quick question on that subject?
Yeah.
So I'm curious, how deeply quantitative do you have to get? And by that I mean, let's say you want to get an athlete into the country, get his visa, and that particular athlete has, been selected to sort of a first-tier representative side in whatever sport. Would you actually say that there are 20,000 players in this sport in this country, and this person was selected as one of 100? Would that have any credence, or is that still too broad a definition quantitatively?
I love to use the pyramid. That's what I call that, right? So if you can define a process through your experts that build a pyramid on, how many people are in the sport, and then build it up, right? So there's this many people in the sport, there's this many are competing at this level team, this many at this level, this many at this level, and this person won something, then you've got a quantitative methodology that your experts can give some analysis on. It's good to provide your experts that data if they don't have it themselves. Many times they don't know it. They don't. Why would they look for it? So you can help them get that. That's what we do, and then we help build that pyramid. But it depends on what it is, right? So sometimes that is a membership in an association that requires outstanding achievements. Sometimes it might be, and we'll go through some of the other criteria where that may come up as we go through that. But I'll recall to go back through the pyramid where the pyramid may work. But yeah, giving your expert data to rely on is much better than just their opinion. Thank you, Bobby. That's a great question. Trisha Newman asked if there would be slides available at the end of this, and yes, we can share the slides for this. Guys, if I can do that. Okay, so case example is, which one am I up here? My thing jumps on me, so let me find out what this was at. Okay, so the case example on membership is Bob Smith was a 100-yard dash competitor with the Jamaican national team. Mr. Smith's participation was an international competitor as an indicator of extraordinary ability and an international coach, according to this case. Now, the athletes that become coaches, this is frustrating me. The athletes that become coaches is a real big dividing line for immigration. Maybe some of you that have done that, or some of you that are wanting to do this, are trying to move in that level. You can be a great athlete and just start coaching, and they will bash your case all the time. So there are some exceptions on this, and this is international level, right? So Bob Smith was an international competitor for the Jamaican national team. If he was to become a coach of the Jamaican national team, that would work, okay? So for any of us that have been athletes, many times the best players become the best coaches. It's not always that case, though. You look in college basketball, Krzyzewski, probably not a very good basketball player, but an excellent coach. And then you have the alternative to that, Magic Johnson, who was one of the best basketball players to ever play, was not a very good coach at all. And I think it's those outliers that cause that. For the most part, people go through this process, and those who competed at the international level are very good at coaching at the international level because they've been there. They've done it, they understand it, and it's just a process. And you're not starting over at the bottom, and you're not an entry-level coach if you play at that level. And that's the argument you make. This is the case we use to win that. I'll move on. Don't use organizations without any threshold for membership. Right, as Bobby talked about, is it a provincial level team that made that? Now, you got to be very careful if it's not international level on that on memberships. But, you know, we've been watching a lot of the only, now before basketball and besides Korean baseball, the only real sport on was rugby in New Zealand. And these teams are provincial all-star professional teams. And making the Auckland Blues or the Canterbury Crusaders would probably be an organization that would have a high threshold because they actually select up to that team from other parts of the country as well and do that. So, but you want to research that. You want to find what their criteria for finding that is and go from there. So a board of directors of nonprofits or a governing body of the sport might be things that you could even volunteer to help on a national body of team. Again, I'm giving you hints on people that may not be there on the O-1 or the EB-1. You can find an organization and join it, and if it's got an outstanding criteria. And some of these organizations might be easier to get into. We had a ski pro out of Aspen that was really good at the science of the body. Right, she had an advanced degree, but that in itself wasn't enough. But she really knew a lot about it, and she volunteered and became part of the German Special Olympic team, and was at the Special Olympics as part of that squad. They loved having her here. She was in North America anyway. That was the year that it was at Whistler in Vancouver, Canada, and she went up, was a part of that team. We used that as part of the evidence, and she won the green card for that. All right, so media, published material about the foreign national in professional or major trade publications or other major media relating to the foreign national's work in the field, which classification is sought. Such evidence shall include title, date, and author. Always use title, date, and author. If you don't, they'll throw it out, throw it back. You also have to have fairly significant types of media, but here's the thing, it can be online. Again, almost every sport has a lot of media on it. One of the things they like to push back on now, as they're pushing back on everything, is it really about that person? Are they significant? We push back on that, but what we always suggest is better is better. The better article from the better magazine, lead with it. Always lead with your best evidence. Don't bury the lead, as they say in journalism. Put it up at the top. If somebody's been in Sports Illustrated, put that at the top. Don't start with the guy started or the woman started when they were 14. No one cares about the history. Go to what their best things are, listed at the top, and go down from there. These folks will lose attention span as they read on, and if you're starting with some stuff that they're not very good, they may predetermine it and not get to the good evidence, right? So that's evidence of it. One of the things that we use to determine if it's major media is researching the readership or how many viewers they have or subscribers they have. Like as media is changing, there's ways to use that too. YouTube's now a big thing. So a YouTube star can have a lot of subscribers, and you want to put that stuff in there. So find out about the publication and support that evidence as well. I'll push on. Let's see what we got here. Okay, the next case example article, Champ wins world title again by Bob Smith in Sports Illustrated, August 1st, 2017. Again, look how we've listed the name of the publication, the date, who wrote it, the title. List the readership of the publication submitted as major media. Example, Sports Illustrated has 17 million readers according to its media kit. You can actually go in and say how many people, how many subscribers does Sports Illustrated have and find that out. But media kit is often in every publication. You can look it up and find that. You can use trade publications, but don't use local publications, right? The hometown newspaper saying hometown kid does well doesn't work under major media. And if you try to put things into criteria that they're really not designed for, immigration loves to play gotcha. They love to tell you you don't know what you're talking about. They love to say, in the worst case scenario, if you're trying to persuade us of this, everything you say is irrelevant or is disingenuous. I've seen that, not in any of our cases, but we inherited some. And I really saw a case once where somebody made an allegation or a statement, and they said, because this statement's wrong, we really don't believe anything you're saying. They don't do that all the time. It's an inconsistent agency, but I have seen it, and you really don't want to be on that. So what you do if you have hometown newspapers that talk about somebody in really glowing lights and really kind of hit all of the facts you want, or some of the facts, put it under comparable evidence, and we'll talk about comparable evidence later. All right. Some pro tips. Does the article have to indicate that the person is extraordinary? Under the plain language, no, right? The regulation does not say that. However, the use of Kazarian, the case we talked about earlier that we'll talk about later, makes you show that you've risen to the top of your profession, and they have to do that. So you're going to have to, it doesn't have to, but they may push back on it. It's better if it does. If you have more than one of these things, then obviously lead with the other one if you can. But if you're arguing like a lawyer, plain language doesn't say to indicate the player's extraordinary. It just has to be about them. All right, so that was a very lawyerly answer. Judge of the work.
Hey, John,
yes, sir.
Quick question. Yeah. In that regard, if you had an article that you put out there and you picked it out, and in it, it's a team sport, would there be value in having a quote where the coach says, the key to our success was having Joe Blow on this squad? Would you highlight something like that?
Yeah, no, we absolutely do. And here's another thing, and that, Bobby, it brings up kind of how you do this, right? So we write briefs, right? And not a lot of immigration attorneys write briefs. They often just put a table of contents and let the evidence speak for itself. And that would be like going into a jury trial and then sticking the evidence on the jury's table and then walking away and letting them figure it out. Now, we know they're going to go argue it themselves later, right? But you really want to be able to go through this criteria and then individually go into the evidence, right? And say, here's what the evidence is, and quote it in the brief, highlight it in the evidence itself with a highlighter or circle it or something. But what I teach the lawyers in my firm is don't make them look, right? Take that quote, put it in your brief up front so they can just read the brief and trust that that's going to be okay. And then tell them there's an exhibit, where the exhibit is, and then show them in the exhibit. So absolutely a great pointer on how to do that, Bobby. Thank you for that. So again, we're talking about judge of the work of others. Okay, so judge of the work of others is an interesting thing. So here's what it's not. Is if you're a coach, you are by your profession the judge of the work of others. So you can't use that, right? What it means is being, if you're invited to judge somebody else. So I was using skiing earlier. So say you're a ski pro or a professional skier and you're invited to judge the X Games, right? Or some other competition. That's when you're the judge of the work of others, right? That's the kind of thing. If you are a coach, but you're invited to be on the team's selection, the national team selection committee, then you're invited to be the judge of the work of others, right? Those are the type of things we use there. It's also one of the things that you can pick up if you don't have enough evidence. Find organizations that you can go judge the work of, right? I mean, find competitions in your sport and go be a judge of that if your sport has judging in that sort of deal. But some sports have selections of teams. Some sports have judging of competitions. These are things that you can pick up to get another criteria if you don't have enough. All right, we just talked about this one, so I'm going to move on. Pro tips. Research organizations that can invite you to evaluate the work of others in your sport. This can be a school, a governing body, or a publication. Many of my athletes, they're all from other countries, and sometimes they're from emerging countries, and they're coming to America because America is more significant, and they have really good relationships with their countries, or they're members of their national team. And maybe they're younger, maybe they're junior members of their national team. They can go back to those governing bodies and be put on selection committees, technical panels, things like that. A lot of times these organizations are underfunded. I know a lot of them in the United States are. So that definitely there are in other countries too. If you can go in there and help out, even if you don't get paid, that's a good way to become part of a national governing body, which is the highest thing you can do in your sport, in your country. So that's it. There's also conference panels. Speaking on your sport can help, but that's only comparable evidence. If you're speaking on your sport and you're judging the work of others. So right now, Bobby and I are speaking, right? This would be a speaking engagement. And if we were live at Sports Lawyers Association, that'd be a speaking engagement. It wouldn't be the judge of the work of others unless we were judging other people's speaking or other people's, whatever they've done. Maybe we're looking at, we're reviewing articles that have been submitted. So maybe if you're part of an organization, look at doing reviews of articles for their conferences. That would be the judge of the work of others. Just a couple links. All right, original contributions. Okay, so not everybody has an original contribution. In sports, I often like to use the Fosbury flop. Fosbury was a member of the U.S. high jump team in the 1972 Olympics. I remember watching that as a kid, and before the Fosbury flop was the wagon wheel, and that's where they would jump over facing down the bar and kind of rolling over the top. Fosbury went and jumped backwards over it. He was able to get a lot more height, and that was an original contribution. Nadia Comaneci, who lives here in Norman, great friend of ours, married to Bart Connor, another great friend of ours. She was the first person to ever get a perfect 10. You can be the first woman to do something. You can be the first person of your country to win something major. Those can be original contributions. If you've invented something, right? So we did some visas for the America's Cup sailing team, and one of the guys, we asked him what his contribution was. He goes, well, these are catamarans, right? So he would go from one catamaran to another one of the pontoons, and he would slide baseball style. His name was Joe Spooner. He called it the Spooner Slide. He was able to promote the Spooner Slide where there were articles written about it, and it really was an effective thing, but it was the evidence of there were articles written about the Spooner Slide and how much faster he could get from one pontoon to the other one safely that helped us use that as a contribution. So sometimes you can get creative to find things. Why am I really good at it? Can I have somebody write about it that's significant, that isn't just a letter? Go out and pitch it to some media in your industry, and if it really is significant, that's a great thing. All right, so I'll move on from there. All right, I think I kind of talked about that. Support your contribution, right? So if your contribution was you helped your national team win something, again, just a letter saying you did it isn't enough. We want to start with, here's the contract that I was the coach for the national team, and then you support that with the letter of what you did as a coach, right? Just putting it in that you did it isn't enough. This is, again, what we see as the biggest reason for denials in this space. And when we inherit cases, often why they're denied is people are just writing these letters and they think somebody important is saying something important. This isn't like a jury trial where someone comes in and puts their hand on the Bible and swears to tell the truth. They don't get to be cross-examined. So, and they also, these adjudicators, they've just found ways to diminish this stuff. And so really just, if you take anything away from this, do not just rely on letters, rely on hard evidence, find hard evidence. If you're, wanting to have an attorney help you on this, help the attorney find that stuff if it's not available online to help them make their job easier to then draft around that. All right, so here's some ideas. It can be, we talked about this, the Spooner slide being a move and the Fosbury flop being a move, an offensive scheme, in football, the West Coast offense that the 49ers ran. The offensive coordinator or the head coach could use that, doing that for a coach right now in another sport. Being the first to do something. You want to support it with pressure evidence. Who's using it? How many? Right. So if you invented something that's really cool and unique, if only 3 people are doing it, they're not going to support it. Right. We've had some tennis coaches that have created some techniques, but not many people were using it. We've had others that have had their techniques, not a patented process, but we showed all the different revenue that was being generated by this tennis process that was being utilized across the board.
John, I hate to jump your presentation, and I'm not sure you'll get to it, but a question just came to mind, which is the unique situation of an extraordinary athlete in one sport wanting to come to this country to compete in another sport. And of course, I'm thinking about the couple of international rugby players who came to the U.S. to play in the NFL.
Right.
How do you take the success and skill and acclaim in one sport and translate it to another sport? What's that argument about?
Well, it would be an issue, right? I would definitely make the argument, though. What was his name? Freight Train Payne, or whatever they called him, the rugby league star from Australia that played for the 49ers. If I was doing his visa, I would use all of his awards in rugby league. And then I would probably use an expert to translate what his athletic ability that was so impressive, right? I'd probably look at things that I could analyze, like, what's his speed? Does he have a fast 40? Is he really strong? Does he have other certain skills that can be quantified and then analyzed across the board? I'd use an expert, maybe either as a scout or a football coach, to say why this guy was so impressive. And, being drafted, if he is drafted, would be something I would rely on. I would look at articles that were written about what he was doing, but you would try to marry it on something objective and not subjective, but you'd have to have a lot of subjective filler, right? And so that's where the better the expert, the better, right? And the better the expert's analysis on why this guy would do it. I've had some athletes, I had some Aussie rules guys. I think I had a guy that was actually captain the Aussie rules team that won the championship in Aussie rules football, and he was a captain of the New York Jets, and he was a punter. And you may remember these guys. There was a couple of them that came through the NFL. They're big fellas. Madden loved them because they would punt, and they'd be 6'3" or 4", and they'd go down and tackle guys, right? So we just put it all in there, and immigration accepted it, right? And it worked out. So that's a great argument, but there would be potential pushback there, and you don't want to just leave it to them to figure out. You want to explain it to them. You want to have experts analyze it. You want to give them data that the experts that can rely on, as opposed to just saying because he or she is good at one, they're automatically good at the other. Same analogy with the coach and player. I'd use that same nexus argument of how a international coach can be an international player can be an international coach argument that they used where one of the cases, and there's not a lot of cases in immigration, by the way, right? So we're really just arguing facts as opposed to other bodies of law where you have this litany of different cases on one side or the other, which makes it a little bit more difficult in some ways. And sometimes you win one because you're just very persuasive and you have some really good, evidence to support it.
Which begs a follow-up question, which in your area of practice, you've brought a very important question up, which I think seems distinct from, what you might argue in court, which is precedent, which is based on case law largely. So you've just said that you have limited case law in your area. What kind of precedent can you use, or is it all just factual and say, here's a case filing that's similar, please refer to it, or is that an exhibit to your application? How does that work? How does precedent work in pushing these things forward without a case law basis?
It's a great question. There is some case law. It's very, very limited, right? So I call this, we're building out a database for our software at OnlineVisas that is going to have this information, right? So it's effectively, there are regulations, right? That's what 8 CFR 204.5 H3.6 is, right? That's the Code of Federal Regulations, and that's the law, okay? So you say, here's what the law says, here's the plain language of the law, and here's what you argue. And as I said, a lot of immigration attorneys don't brief. I was a litigator first, so when I went into that, I was kind of surprised that, you know, these tiny little cases would go in with very little discussion, and they were just leaving it up for the adjudicator to determine it on their own. I'm like, you're not being a lawyer here. You're, you know, what you're getting paid for, right? So so we decided we developed a briefing system where we take the regulations. Then the regulations are then interpreted by policy, right? And one of the things we said here, this AFM, this is the Adjudicator's Field Manual. This is what these guys are looking at, their checklists and how they look at it. So knowing how they're going to look at it is important. That's how does USCIS analyze it? You want to know that. Then they'll have policy memorandums. And policy is really interesting, right? And we'll look at it in this perspective. The President of the United States is head of the agencies. The agencies are then filled with that president's handpicked people, and they have policies, and they make policy memorandum. They're giving these policies, so these are the politicians, to bureaucrats. Bureaucrats might be there through 4 presidents, right? They don't lose their job the same way a policy person does at the end of the deal. They're trained to follow the AFM. And this is a really big issue in immigration right now, because these policies are really different than they've ever been before. There's been a lot of decisions that are being made not to change the regulations of the law, but to just change the policy, and many times they're illegal, and this administration is being nailed time and time again in the courts because of it, okay? Because of that, right? So you have your interpretation of regulations by policy, then you have your decisions by immigration. If they approve it, they don't tell you why they approve it, so there's no precedent to get anywhere. If they deny it, then they will tell you why. So you don't want to use that precedent, right? And it's not precedential anyway. If you appeal it through immigration's own appellate agency courts, it's called the AAO, they'll give you a decision, and that decision is not precedential. It even says it there. It just says it's only persuasive. So we'll use it because once in a blue moon, they will overturn the determiner, the actual decision. Not very often. So if you can find a good one, you can use it as persuasive, and you put that in your brief. If it goes to federal court, the thing about federal court, it has to violate the Agency and Procedures Act, the APA. And in order to violate it, it doesn't just have to be wrong. It has to be so arbitrary and capricious, that's a term of art, that they'll overturn it because they just didn't follow the law at all. Not that they decided, in their opinion, they didn't think this person was good enough. So that doesn't happen very often. But what they'll do from time to time is put up a case in there to get a decision, and they'll set a standard really high. And there was a golfer that they've used as part of this deal. So there is some case law out there. So it's sort of a little bit like the Wild West. I've argued in tribal courts before, and it's a little like that. It's not really, it's more seat of your pants litigation. And you go in there and you persuade as best you can, and you're dealing with not an opposing counsel as much as the opposing counsel and judge is one person. So you have to be careful. You can't argue the same way you would against opposing counsel. You can't say that they're being unreasonable or dumb or it's a crazy argument. You really have to argue like you're trying to convince a judge, or as I say, educate somebody, right? So this is where we would just educate them through our experts who would be evaluating this evidence and not just saying what's obvious, but coming from some perspective, right? There's right there is extraordinary ability immigration, or immigration in a nutshell. So thanks for raising that, Bobby. I'll move on to the next criteria. Does the article have to be extraordinary? Under the case of Kazarian, now here is a precedential decision that sort of evolved in immigration, right? So when Kazarian came out, here's what it says. The petitioner claiming extraordinary ability, oops, this is frustrating, need not submit extraordinary evidence to prove that he or she is a person of extraordinary ability. Doesn't that sound funny? So if one evidentiary criteria requires a showing of a scholarly publication, the petitioner need not establish the scholarly publication in themselves are also extraordinary, right? So if you have a scholarly publication, just having one's enough. It doesn't have to be a great scholarly publication, just a scholarly publication. Okay, so when this came down in 2010, we jumped for joy in immigration. Woohoo! These guys have been beating us up. They're making us prove beyond the plain language of the regulations, and these guys saved us. But then Kazarian turned, And it then decided that all the evidence in itself has to show that you've risen to the top of the profession. So essentially, how they're using Kazarian is different than what Kazarian actually says. And if you understand that, you're a better man than me, because nobody really does, but that's what they do. Pro tips: USAS may only recognize scholarly articles. You may attempt to use technical articles if not in academia. This doesn't always work, but in sports, I've done this. I've used manuals from people that are in sports that are in the governing body, and they use manuals or books. Even though that doesn't always work, sometimes we'll push that. What you don't want to do is blogs. What you don't want to do are puffy pieces. But if you're writing technically, that can work. Again, if you're speaking at conferences, say you're a strength and conditioning coach, we have a number of them. Strength and conditioning coaches are, as coaches go, may not be the top of the food chain on the coaching staff, but they sure can prove a lot of this stuff out a little bit more because they have scientific backgrounds, and then they can write scholarly articles on it, whereas a head coach really can't. That's a totally different thing. So just an interesting thing there. So moving on. Critical role. Okay, a leading or critical role for organizations, establishments that have a distinguished reputation. So a couple of things there, a critical role and an organization that has a distinguished reputation. What do we look in sports is, did you win any championships, right? Did you win any championships in what you did, right? So make sure that championship, though, is a high-level championship. Sorry, this thing just jumps on me. So level 2, or here's where they come out against us all, age grade, right? This person was a collegiate national champion. That's not the highest level in the sport. Very frustrating to hear that, right? Winning a collegiate national championship is a significant thing. It should not be diminished just because there's a professional level of play. They'll do that with under 21s, under 18s, junior, Wimbledon, things like that. They often do that. So we will use it, but we'll want to find some other things too. But if you win a championship at the senior professional level, that might be better than winning it at the national level or world level as an amateur, right? They're really coming down hard on that. So just understand that that's out there and do the best you can to deal with that. But that's one of the things that they're doing. But critical role, you need to show what that role is. Now, this is where you can use letters, okay? This is the time where you can use a reference letter. So you got to show that you're on the team. Is there a program? Is there an article? Is there a contract? And then that you had the role of captain or whatever it is. And this is where you have the duties broken down by somebody within that organization. The more independent, the better, but sometimes you just need to have the coach or something do that. Remember, we said letters by themselves are not very good. There's times to use them. Another thing that people make the mistake of are using reference letters instead of expert letters. What's the difference? A reference letter is your boss. That's your coach that's talking about you in this sort of deal. Use your coach to talk about your duties and what you did for the team in a very specific way. Don't use your coach to say, I'm an expert, I know what is a good award. Use an independent expert for that. But both of those opinion letters are secondary evidence. And again, that's the mortar around the bricks. They can explain the bricks, but you better have some bricks in there. All right, moving along. Case example, I'm just going to move past that. I think we got that. I think we've talked this. High salary. Okay, high salary. Now, a lot of people come to us from other countries. Obviously, they're immigrants, right? And they may make a lot, or their amount of money they made in their country may not be very much in America. South Africa right now has an 18 rand to each dollar. So the American conversion of that's not going to be much. So, but that's okay. What you need is data, right? What are people in that profession making in their sport? And if you can find that data, then you show how this one's at the top. And that's how you would deal with that. Don't try to do it without data. They'll throw it out. Oops. Okay, there's high salary. All right. Moving on. Comparable evidence. Okay, so we talked about comparable evidence. That's stuff that doesn't meet these criteria, but still might be really important, like speaking on a panel at the Sports Lawyers Association. Not one of the criteria. but important, right? Comparable evidence. Article about you in your hometown paper talking about how you did some really great things. That's not major media, but it's comparable evidence. State awards are worthy. This is where you might put the amateur awards, right? So if you really want to beat them at their own game, you put it on comparable evidence and say, look, they won the US Open Juniors or the Wimbledon Juniors, right? And you get it in that way. Or you can try to say, look, this person was Rookie of the Year and in the NBA. If you don't think that's a national award because that they're a rookie and they haven't risen to the top of their profession, please see it as comparable evidence. You can do it that way as well. But use comparable evidence. All right, kind of said that right there. All right, the final merits determination. This is where Kazarian comes in, right? This is where we told you that the plain language said they just have to have, that they're in an article, they just have to have published a piece of a scholarly article. The final merits is where it's now a two-part adjudicative approach, right? So they're going to say, did you meet the three? And then after you met the three, does it indicate they've really risen to the top of your profession, right? This is where you want your experts to do it. Here's some cases: Bulletini, Rigel, Nerozzi. These are different decisions. I'm not going to read you guys a bunch of case law, but if you want it, I'll let you see it. But these are different things that go to that. I talked about the unpublished AAO decisions. There's some good ones in there that can support these arguments. Gucci versus Kelly's another one. These are cases that, Brazil's PBR Rookie of the Year was rejected, and they went back in and they conflated the two-steps method. There's some things like you can use from this case law more than in other types of immigration law that because this is so subjective, right? So that's kind of it in a nutshell. Let me see where we are on time. We got about 15. Go ahead, Bob.
I have questions.
Sure.
For the uninitiated, as non-immigration lawyers.
Sure.
So I assume, which is always a dangerous thing for a lawyer to do, I assume that there are different levels of visa to come and play in this country. And the title of this is about the O-1, and I think it's the EB-1 green card.
Right.
My question is, I'm a European tennis player and I want to come play in the US Open.
Mm-hmm.
Do I apply for an O-1 or am I getting some other kind of visa? I'm just here to play an A tournament.
Yeah. So there's three visas that you could actually use. One is and I'll kind of take you through them. One's the B visa. That's the visitor's visa, which actually has an interesting exception because there's some business and visitor elements of that. One of them is you can come to compete in a competition for prize money and actually receive that prize money. That's the visa that a national team may come over to compete in. The World Cup was in the US, right? Or the Toronto Blue Jays come into play against somebody else. They are members of that team. They're coming in to compete. But we've had a lot of scenarios where people were blocked. I remember a tennis player from Russia was actually detained up until, I think she was detained for 17 hours, and she was the person that got Serena Williams as a draw. She was 64. Serena was 1. She got out 3 hours before it, had to catch a cab across town to get there and then get whipped. And if you're going to get to play at that competition, you don't want to be spending 17 hours in jail, right? So what we've done with a lot of folks is we move them to the P visa. The P visa is a lower standard. It's not extraordinary, but it has some hair on it a little bit. So in the P visa, you have to be competing exclusively. You can't also be a coach, things like that. Now, we used to do them as coaches, but immigration has really gotten that down. The only exception to being an athlete under the P visa is endorsement deals. So we do that. So the O is a little broader. So, and you have to be competing at the highest level in a P. And O, if you've been extraordinary, you can compete at any level. You can compete at an amateur level, coach at an amateur level. You can compete and coach. You can do various different things because you've proven you're at the top of your profession, right? So those are sort of the different visas there. Now, those are non-immigrant visas, temporary work visas for a period of time. It can be a season. It can be up to 3 years on an O, 5 years on a P. The B is going to just be 6 months. And if you try to stay and work out and train on the B, they're not really going to allow you to do that. That's when you're going to move to the P if you want to come in besides just that competition. The EB-1, what that means, that's employment-based one. That is a green card. That's permanent residence in the United States. And that means once you get the green card, you're permanent. There are some, you can leave the country, you can come in and out on it. You really don't want to be out more than a year. If you're out more than 6 months, you better establish some home base here. But a lot of our clients are competing all the time in their various places. But the green cards are really big perk. And EB-1 means it's the top of the food chain. That's for the extraordinary ability. Good to talk about that.
And in the space, I know we read about how so many federal departments are being cut back on and less people working and across all sorts of federal agencies. Have you seen that in immigration where there's less examiners and it's longer time windows and you have to plan for bigger opportunities? Your client calls you and you can't say, oh, I can turn this around in X. Now you have to say, I don't know how long it's going to take. Has it gotten to that point?
Well, the I don't know is a much bigger question than it ever was in immigration. It's an inconsistent agency. Time is the O-1, we say it's about 4 to 7 months, even with that before COVID, right? And then getting in the country is interesting. There's now a national interest exemption. We're working with the U.S. national team and a couple other athletes trying to get in from Europe because they're barred right now under this exemption. And this administration says you have to work directly through the acting Secretary of Homeland Security, Mr. Wolf, to get that exception. So it's really interesting right now where that all plays. There's still premium processing available for 15-day adjudications on the O's and the P's and the other non-immigrants. But then they got to get through the consulate, and if they're in those barred countries, which quickly go over is Europe, because it's called the Schengen region. UK's added to that, China, Iran, Brazil. Other countries don't have that, but their consulates may be closed. So these are all difficulties right now that are there. Now, to add the whole thing on examiners, we've been okay on examiners, and this is fee-based, and they've been able to handle it, but their money's about to run out. And at the end of this month, in August, they may furlough them, and they've already given them their letters to furlough them. And we're talking about thousands of people, and it would really slow everything up if that happens. What happened is that was going to go into effect early August, but Senator Leahy from Vermont, who's a really big kind of advocate of immigration, allocated some more money, moved some things around to get it to the end of this month. So we're hoping that happens and they don't just keep it shut down. But immigration's a political football, and that may happen. Hopefully, if it does happen, it won't happen long, because there's a lot of important people that need to come in to compete in these events, not just in sports, and all industry in the United States that are very necessary. So I think that won't happen, but it's actually out there. As far as it is right now, it's really interesting because it's a really good time to do immigration, because a lot of people are just chilled about it. I mean, there are not as many cases are going in. We're finding, ironically, a higher approval rating right now and faster adjudications for extraordinary ability than we've seen prior to COVID. Go figure. So consistency is not the word of the day when it comes to this agency. So that's why these tricks, these methods are good, because different cases get handled differently, and the better you can do this, the better your result should be. And that's why we want to educate on how we do that and those sort of things. And that's why we got a slide up here. We've got a 95% approval rating. Immigration on some visas is down around 60% right now. We're not just doing it because we're smart guys. We think it's our process. We brief, right? And we put a lot more effort than we're seeing other firms typically do. In this, we use the experts. We work with the experts. We get good experts, and we help them write these letters in a way that they'll be persuasive to the point that the immigration examiner needs it. And when we inherit these cases, a lot of times, Bobby, there's just somebody says this person would be a great asset to America. They're really great, and you're gonna love them. They love America. It's nice things. It's irrelevant or more things that like, why would you want to hire them, not how do they meet these criteria that are effectively a checklist for these adjudicators. And if you're just telling them fluffy stuff or it's buried in there, they're not patient. You know, they'll just like, oh, that doesn't help me any. And they'll just make the call on their own. And then you've lost that opportunity to adjudicate and help educate why this person deserves this extraordinary ability standard. And the extraordinary ability standard is subjective in itself, right? So two reasonable people could disagree on this, and that happens sometimes. So and another thing to know is if you get turned down on one, you can refile it. It's not like finding that someone's committed fraud or broke the law or something like that, which can be punishable. You can always have another go at it, and with a 95% approval rating, that means 5% of the time they don't go through. And so we've taken cases that have been denied, repackaged them a little bit, had some more analysis, got another expert or two to drill down, and got them approved another time after that. And that's happened significantly more times than not. So don't fret if it happens to you, either as a client or as an attorney. Have another go for it. This is a subjective person that you're going to likely get a second person or a different person the next time you put it in. And that's not a bad nugget if whoever's listening to this is either trying it on their own or trying to do it as an attorney. So do we have any other questions, anybody? If you have any, ask them out there. We kind of powered through this stuff pretty quickly, and it looks like we got some sharp folks on our group there. But let me see what else I have. That's the question section. That's kind of the end of the deal. All right, so we have a few minutes. Bobby, anything else you want to talk about? Any other questions you have on immigration?
No, this has been great. I think it's oftentimes really beneficial that we sort of tie the law as it is, as you've laid out, and the actual practice. And in immigration law, it seems to be different from other areas of the law, and it's changing more. From my outsider status, it seems over the last 3 years, the role of the immigration lawyer has changed to the point that, much like Alice, when asked, "How are you today?" you have to say, "I don't know. I've changed so much since this morning," because
sure.
it's completely evolving. So I think, immigration is one of those areas when people say, "Well, you're a lawyer, you can handle it." And I said, "Well, sure, I have the skills to do the research and figure stuff out, but a discipline that I'm not an expert in, I'm going to reach out to an expert." And I think you've shown us today that there's way too much nuance to try to fumble your way through it, and that immigration lawyers are out there because they figured a better way to fumble through it as it changes on a daily basis. So I think it's really been beneficial to learn a lot today. I think, we covered a tremendous amount of information, but I think it gives a nice high-line view of, just because you're a great athlete, you have more athletic feats of hoop jumping to go through if you want to come work here in the United States. So it's been great. If anybody has any questions about the Sports Lawyers Association, please go to sportslaw.org. There's a lot of free content, and if you want to become a member, we welcome you to become members. And if you're a member, you get exponentially more content behind our paywall. Really valuable stuff, from standard contracts to a bunch of other, content. So, John, it's been great. Thank you so much for letting us be part of your webinar here. Very instructive. I learned a lot. Thank you for everything.
Thanks, Bobby. If I can weigh in support of Sports Lawyers Association, I think I've now been in 12 years. I've been going to the conferences and been a member. And I tell you, sports law is a fantastic body of law, especially if you're a sports fan. It is the conference is fantastic. Bobby is the president and has for many years run this conference, and been very loved being a presenter. But I love just going and listening to the things. And as an immigration attorney, there's a lot of this law isn't relevant to me, except for when it comes up that I need to refer to somebody else. And I've done that a number of times tax lawyers, agents. I've got to work with them, and I really got to learn a lot about how sports works from a lot of the front office guys, right? The various, all the leagues are there. Their counsels there, the agents are there, and it's really interesting as a sports nut, and I consider myself that, to see that, and to seeing, you know, what's happening when leagues are going into, you know, maybe into a strike, and how they're posturing and stuff like that. Our conference has been excellent to show that, but I think I've enjoyed a lot just the camaraderie of the different lawyers and how great they are, and how many different people have showed up this conference and found work out of it. You know, we both know a number of people that have come in. There's a lot of law students that go to it, and a lot of lawyers that have moved around between the different bodies or different entities around sports law. I've really enjoyed SLA, and I'm really happy to, I've sponsored it a few times, and I love going to it, and all the friends I've made in it. And so if anybody out here is listening, that's, you know, involved in sports, it's a great place to go. It's a great place to learn how these things, and how often these different organizations will knock each other. And then the stuff that you guys present is so helpful. We've had a number of our clients, we've invited out some guys from Major League Rugby, and other bodies of law have gone. I've invited out. I've had some kind of even join us on our panels to just introduce it to them. And I know almost to a person, everybody that's come involved with it has come away, you know, enjoying the experience, and many times, you know, increasing professionally by their involvement. So thank you, Bobby. It's great to do this with SLA. Couldn't say enough nice things about your organization and all the work you've done with it.
Thanks again, John. Talk to you soon.
Guys. Take care, everybody. If you want anything, please email me. There's all my stuff below. Email address, website, phone numbers. If you need anything, please communicate. Take care.